abusuafoɔ ne adɔfoɔ a mo nyinaa kɔ abɛbiem Alpha OneTV ha na aba a wɔte nsɛm a ɛden sɛ wobɛto other platforms so no ha na ne nyinaa yɛ den ɛtwa gu nti sɛ nkɔ baabi a so nsa aka bia no ayɛ den ɔlike ahyɛ ama onyaa so ayɛ den ɛnyɛ bi ɛti no nso keep updated yɛn sɛ already yɛmfa ani nkyerɛ mu ne yɛnka deɛ wɔn nkyerɛ mu na saa bere deɛ yɛtu faa deɛ ani akyerɛ mu Supreme Court because ɛnɛ ɛna kyerɛ sɛ ɔmo hyɛ bɔ sɛ ɛyɛ NDC foɔ ɔmbɛti ɔmo nsɛm nyinaa ɛde fa ɛyɛ EC ɛyɛ case no ho ɛne ɛyɛ high court case akyerɛ sɛ wambɔ no ho mmɔden koraa mpo sɛ ɔbɛtie NDC foɔ a kyerɛ sɛ ɔmo yɛ interesting party ɛwɔ case no mu no wɔntie ɔmo asɛm na ɔtie one part ɛkɔyɛ recollation no ɛnɛ na Supreme Court sɛ ɔbɛtena ase na kyerɛ sɛ deɛ ɛwɔ bia no ɔmo de ahyehyɛ so nti ɛnɛ ɛyɛ yɛnyɛ akwanya ɛbɛtie ɛyɛ live ɛyɛ scenes anaasɛ ɛyɛ program a kyerɛ sɛ ɛkɔ so ɛyɛ Supreme Court na kyerɛ sɛ NDC for bomb homodin yi papa ɛyɛ honorable ɛyɛ Tamaklo eduji Tamaklo na kyerɛ sɛ odi anim na sɛ deɛ wa provide with evidence Jesus abre ɛyɛ Mensa na ho hyehyɛ ne pa wa provide with evidence abubudin a 7-seater just a declare ama a NPP for just a illegal pay NDC forced a statement and as some canon. It is illegal and not just say on this cases in Inako Pimo Supreme Court not just say evidence a eduji Tamaklo a de go on any evidence kitwana. Sabi as we speak no was silence a NPP for a lawyer some good jinemu a ɔmo nyinaa ne EC nyinaa no na sɛde wasi a convince ɛyɛ Supreme Court no provide with fact with the law with nneɛma ɛkɔɔ so ɛtase no police station no ne nyinaa kyerɛ sɛ wɔayi akyerɛ ma kyerɛ sɛ ɛnkyɛ really ɛbɛbɛ kyerɛ ne.
My lords, we have before you an application invoking the supervisory jurisdiction of this honorable court. My lords,
yeah, our recording system is working, so we don't have to write everything verbatim.
Grateful. My lords, I move in terms of the motion paper, the grounds set out in the motion paper, the affidavit in support, the supplementary affidavit in support, the statement of case, and the exhibits annexed to the application. My lords, our ground for this application is that the order made the orders made by the High Court were made in breach of the applicant's rights to be heard. But the further ground is that the trial judge demonstrated apparent bias and partiality. 3, that there was a non-jurisdictional error of law by failing to exercise the court's powers under Order 55, Rule 5(2) of CI 47 to direct second to sixth interested parties to serve the mandamus application on the applicants who have interest in the subject of the dispute. And finally, error of law apparent on the face of the record, which error of law occasioned a substantial miscarriage of justice to the applicants. My lords, I wish to draw this honorable court's attention to exhibit to exhibit 5 series. Oh, sorry. My lord, a brief fact I think will be important in this matter. My lord, an application for mandamus was filed before General Judicial 13. Now, at the hearing of the said application, after counsel for the applicant and the respondent announced themselves, I drew the court's attention to a joinder application. The trial judge,
go ahead.
Yes, the trial judge requested I show him a copy of the joinder application. He therefore asked his clerk, a lady clerk, to come for a copy of the joinder application, looked at it, and proceeded to write his ruling. My lord, the ruling we have exhibited to the supplement, the supplementary affidavit, as the B series. My lord, in exhibit B1, the trial judge clearly indicates, and my lord, with your permission, I just want to read the portion. Page 2 of the ruling. So, therefore, the joinder application notwithstanding, it is not safe. An offense rule 20.
Now help us. Which of the applicants' ruling are you reading?
Oh, my lord, with respect, that's
mine actually is the rulings are exhibited as exhibit A.
Yes, but in the supplement it comes as exhibit B series.
Okay, I have it as
in the supplement.
Okay. Now, which applicant's ruling are you talking of?
This is court applicants.
No, we have Nana Equia Owusu Afriye ruling.
We have the one I have with me is that of 4th applicant.
Mention the name because we have.
Amenope Philibert.
Okay, that's fine. There's Patrick Yaboama.
That is so, my lord.
There is Ajay Mensa Kosa.
But this one is Expertise Frank Ano Dompre.
This is what we are looking.
Oh, very well.
Because that locates it easier for us.
B1.
Anyway, but once we get the name of the applicants.
Expertise Frank Ano Dompre.
Not them, right?
Page 2 of the Expertise Ano Dompre ruling.
Just 1 minute, just 1 minute. There's so much paper.
So, my lord, with respect, exhibit B2.
Okay.
Expertise.
Which one are you reading?
Expertise Yao.
Which one are you reading from?
So, my lord, I wanted to read Expertise Frank Ano Dompre, page 2
Yes.
of the ruling.
Yes. So Now we're on the same page, yeah.
Yes. So it then says, therefore, the gender application notwithstanding, it is not said an offense under 20 Rule 14. The application is granted as yet by is ordered to collate and declare the winners of this election. So it proceeds. Yeah. My lords, again, in Exhibit B2, ex parte Patrick Yawama.
Yes.
At the same page 2. Quote, therefore, the gender application notwithstanding, since it is not said an offense Rule 20, the application is hereby granted.
Yes.
Exhibit B3.
Now, so, and your point is?
The point we are making is that at all material time, the fact that was before my Lord was that the applicant herein, whose interest will be affected by that decision, ought to be heard. And that failure to afford them a hearing before the decision was given offends the Odi Ateron Party rule. And that offense cannot be cured and should result in the invalidation of the decision by the trial judge. My Lord.
Counsel.
Yes.
So you hinge it on the application for joinder. Failure to grant you a hearing that is anchored in your application for joinder.
No, my Lord.
Is that the case?
No, my Lord. First of all, my Lord, I just want to draw the court's attention to something. Yes. Order 55.
Yes.
Says 2.
No, let's look at the issue of joinder first.
Okay.
Yes. So as far as the failure, alleged failure on the part of the trial judge to hear you, your case is anchored in the application for joinder, whether partly or wholly.
No, my Lord, maybe partly.
All right.
Even without the joinder, with respect, even without the joinder, right, by reason of the provisions of Order 55, 6, Rule 5, 2, it says that a notice of application shall be served on all parties named in the applicant affidavit as being directly affected by it. 2, the court may order that the notice of the application shall be served on any person not named as being directly affected by the application if in his opinion it is desirable so to do.
So that is the 55 prescription.
That is 55 prescription.
Yes. And you mentioned the joinder application, so I'll bring you back. Now, your application for joinder was based on Order 4. Was that the case?
That is correct.
If you have your rules with you, look at Order 4, Rule 5. Order 4, Rule 5, Sub Rule 5. We start from Order 4, Rule 5, Sub Rule 3. The provisions there indicate what must be done when the court decides to grant an application. Can you read 4 Rule 5.5?
Yes. An order is made. Under Sub Rule 2, the writ shall within 14 days after the making of the order or any such period as may be specified in the order be amended accordingly.
So, yes.
Endorsed with the reference to the order in pursuance of which the amendment is made and with the date on which the order for the amendment is made.
So it talks about a writ.
That is correct.
Yes. Turn to Order 82. A writ has been defined by the rules. I think it's the very last word.
Yeah, the definition.
Under the interpretation section.
Yes.
What does it say?
My Lord, it says a writ includes a writ of summons, statement of plea, or a petition in a cause or matter.
So it doesn't include the application before the trial judge.
My Lord, it's an originating process.
Yes, but it's not a writ, as defined by the rules.
You see, my Lord, the word used is includes.
Now, would you say that the provisions in Order 55 are cognizable to the joinder and Order 4?
My Lord, the provisions
Yes.
of Order 55.
Yes. Because you see, by your own showing, Order 55 has prescribed means by which the court can hear a party whose interest will be affected. You understand?
Yes.
By service of the affidavit. So would you say that that provision, an application under Order 55, will recognize a joinder application under Order 4?
My Lord, it should. And my Lord, the reason is that, my Lord, with respect, the reason is that the rules on joinder,
Yes.
unless there is a specific provision detailing how an originating process should be done differently other than Order 4 is applicable. And my Lord, if you look at the reasoning of the trial judge,
Yes.
he did not reason that the application was brought pursuant to Order 4, for which reason he was not going to hear it.
Having said that,
So I'm just pointing out.
I was asking whether giving
abusuafoɔ nneɛma a ɛkɔ so supreme court hɔ no na kyerɛ sɛ ɛgu so de brɛ mu no ɛmu ɔhyie papaapa ɛdɔgye tamaklo na kyerɛ sɛ wasɔre agyina ama ɛyɛ nkurɔfoɔ a yɛrekyinkyim wɔn nsa agye tumi ama nkurɔfoɔ a kyerɛ sɛ ɔmalusi yes nkurɔfoɔ a ɔmalusi ɛna yɛrekyinkyim wɔn nsa de ama wɔn ɛdɔgye tamaklo afa asɛm no abɔ ne bo so na kyerɛ sɛ ɔredi ma ɛyɛ NDC for pa kyerɛ sɛ nyɛ asɛm ketewa 5 judges ɛna kyerɛ sɛ ɔmo te hɔ a ɔmo yɛ hearing no ɛgyina ɛyɛ the whole supreme court ɛgyina ɔmo anan mu ɛyɛ saa ɛyɛ hearing na ma ɔmo na etie ɛdɔgye tamaklo nsɛm na ɔtumi sɛ ɛyɛ one judge ɛtry sɛ nka ɔbɛyɛ den ɛbɛ challenge no nanso so no ɛdɔgye tamaklo akyerɛ sɛ wabɛn yes wabɛn na onimdeɛ kɔ he needs justice for these people because I didn't think court is there for justice that is why they call them my lord so justice place no ɛba ne sɛ yɛtumi tie ɛfa baako ne ntie ɛfa baako wokɔ ɛyɛ radio station ante na akora mpa yɛnim no ɔhɔ kora mpa a ɛnyɛ court no mpo no obi di n'asɛm ɔba a yɛtie other side bia na asɛm no wama na yɛ de too much na yɛtie the other side yes saa ne ɛyɛ no na wontie ne nyinaa na wogyina afa baako ka sɛ yɛnkɔ recollection a na kyerɛ sɛ asɛm no ɛmu ɔwerɛm kakra and we know sɛ sɛdeɛ yɛnim no yɛsi wodi kan wɔ court a ɛnkyerɛ sɛ wadi bim these are the statements a yɛn nananom mpanimfoɔ yɛ den ɛtena ase kan and they know the reason why a ɔmo ka asa because obi betumi di bɔne no wadiri mika yɛ den ɛkɔ court ɔno no adi kan kɔ court despite the fact ɔno adi bɔne no ɔno adi kan yɛ den ɛkɔ court te ba ne saa na akɔ yɛ sɛ nipa na odi kan court ɛkɔ court no ɔno nkɔ kan de wayɛ o till sɛ ɔbɛfrɛ the other side ɔno nso so ɛtie ne nsɛm yie with the law nneɛma justice ayɛ apie no yes ɛno ɛna ɛyɛ sɛ yɛfrɛ ne sɛ court of justice yes supreme court of justice high court of justice ne de justice na yɛ aka ho na yɛtie fa baako ne yɛgya fa baako ne yɛsi kɔ no akɔ yi wɔ yi anaasɛ wogyina without any evidence na kyerɛ sɛ wode ruling aba na kyerɛ sɛ woanyɛ fair that was the reason why Edoji Tamaklo can say when we set this precedent it's very dangerous. Yes, it's very dangerous to our democracy. When this precedent is set, it is very, very, very dangerous to our democracy. Or can say Judge Bako on this statement and I see you say so you don't know say Sa sama ba ne etia fa ba ko pe. Na se fa ba ko na wetie no make say ono krampo no unim so odi bi ma no so odi fo. Na so ugina no kwa so e dey ruling. You don't know say e dangerous. You don't know say the trust krampo ani pa be wo court no krampo no. Ever from. You don't know it's a threat to a democracy because how democracy say kebi na me ma min kebi. Wanka se won ko aka was it kebi na me so min kebi. Na okugina fa ba ko pa ni pa ba ko pe kasa na so dey gina so dey ruling ba. You don't know it's very dangerous. It's very, very, very dangerous. Niema ECJ Mensa moye no. Niema ECJ Mensa moye no. Muji dimboni o. Muji dimboni se be yanka masesa. Because that office one nipa we bri aba no moko. Ti mo adin a muji to we e dimpa. Anase dimboni. Man force what the fan say you are there to serve a political party. Unya be run that office one cramp no. I was said the office nemra necessity no who did so because that office is an independent body. Just a new to show be and customer pressure be about so. It's an independent body. And I say, well, the whole service and political party. Yeah. As a court crack as I won't find you, man. As someone yaba. Someone yaba. This is not one, this is not two. Why be the bree? Not just saying yes, we had the in with the course or just saying yes and Semi Brenana air pop up in the Supreme Court, such as you don't update in your bedroom and could be asked.